Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Today we're bringing you a special bonus episode, brought to you in collaboration with the folks over at the Legal Writers Collective. Go on and check them out on our website or at legalwriterscollective.com. Hope you enjoy. The Queen and Antrobus. Heard on July 6, 2020 by teleconference. On appeal from the conviction entered on November 15, 2019 by Justice Maureen D. Forstall of the Superior Court of Justice. Reasons for decision. The appellant was convicted of 2 firearm-related offenses. He was given a global sentence of 3 years incarceration before credit. He appeals the convictions on the grounds that identification was not established beyond a reasonable doubt. The police breached the door of an apartment building in order to execute a Feeney warrant. Several police officers watched as an occupant threw a package from the balcony. This package was recovered and contained a Smith & Wesson handgun. Although one of the officers testified that he recognized the appellant as the person who threw the package off the balcony, the trial judge did not rely on his identification evidence. Instead, she concluded, based on the circumstantial evidence, that the only reasonable inference was that the appellant threw the package from the balcony. The appellant submits that there were reasonable inferences other than that it was the appellant who threw the package from the balcony, meaning that the Crown's circumstantial identification evidence did not meet the standard of proof beyond a reasonable doubt. See the Queen and Villa Roman. We do not agree. As officers entered the apartment, there was a loud bang which was temporarily connected to when the officers outside of the apartment saw the package being thrown from the balcony. In satisfying herself beyond a reasonable doubt that it was the appellant who had thrown the package, the trial judge accepted and relied on the circumstantial evidence that 1. After the door was breached, officers had an immediate view of the apartment. 2. There was only one person in the balcony. 3. P.C. De Silva, who was outside, saw the person throw the item. 4. P.C. Moore called for the appellant by name. And 5. P.C. Reigert and P.C. Christodoulou were watching the balcony door and saw the appellant come through the apartment. The trial judge also found that there was insufficient time for any of the other persons in the apartment to have thrown the package from the balcony and to have re-entered the apartment. We also conclude that the trial judge was entitled to find that the only reasonable inference was that the appellant knew that the package contained a prohibited firearm when he threw it, that he had the requisite knowledge and control of the firearm, and that he was in possession of it. She found that the appellant threw the gun from the balcony to avoid it being found by the police, and that the shape and weight of the gun would have been evident to anyone handling it. She also found that there would have been no reason to throw away a BB gun to avoid its detection. Under these circumstances, it was open to the trial judge to conclude that the only reasonable inference available is that the appellant had possession of the gun and threw it over the balcony. The appeal against the conviction is dismissed.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.